Ain't nothing wrong with my internet. Come on, stream y'all. This my last one. All right, real deal. We are at our last part three of the hearing. Let's get through this. I appreciate y'all.
As it applies to my client who was record some rap lyrics in 2019 is what the state said. But I don't know if this is supposed to be considered admission or mens rea. I'm not sure. That's a little unclear. But what he allegedly said, I just beat a murder rap, paid my lawyer 30 for that. First of all, I was not his lawyer. Secondly, he did not beat a murder rap. He was wrongfully arrested in 2015 for the murder of Donovan Thomas based on the testimony of an individual who lied about his name to the police while giving my client's name. He was arrested with 3 other people. The state dismissed charges against 3 other people and now say those 3 other people are wholly innocent.
Oh, Mr. Farley's still a co-defendant.
Mr. Farley's not charged in that murder, and he never was. But they dismissed the charges against the 3 other people that he was arrested with and realized they had no case against Mr. Stillwell either, which was the subject of my motion for speedy trial, constitutional speedy trial. So he was released on bond. He didn't beat the murder rap. He was wrongfully arrested and released on bond, and they admitted that they completely arrested the wrong people.
They saying that particular admission is relevant for the following purposes: actus reus to show enterprise and gang affiliation, and then under the mens rea prong, state of mind, intent, motive, or knowledge.
He didn't say I killed someone and got away with it. He said beat a murder rap. Paid my lawyer 30 for that.
They're saying that as it pertains to your client, it's a party admission.
So Your Honor, I guess if I'm wrongfully arrested for a crime and then I write a book about it, I'm somehow admitting to committing that crime? That makes no sense.
Well, if you write a book about it and tell on people and tell on yourself,
he didn't do anything.
He comes back and says, oh, by the way, he wrote a book about it, and we're going to introduce it against him, and we're going to let a jury decide whether or not it's a confession.
And if he said I beat a murder rap that I did with Johnny, Steve, and Billy, then I would tend to agree with you, Your Honor. He said I beat a murder rap, paid a lawyer for 30. That means he went to court, he got released. How that is an admission is beyond me. He's telling that he went to court.
Well, I mean, its context as well, and it may be relevant. I think that's for a jury's consideration. The threshold issue is whether or not it meets either actus reus or mens rea, and under 24-4-401, it's logically relevant to some particular offense or element.
And it's not logically correct. It's distasteful. I think.
Okay, we're gonna have to. Okay, that's your opinion, and you're entitled to it. Okay,
Your Honor, going to court has nothing to do with committing a crime. Being falsely accused of a crime has nothing to do with committing a crime. He's merely saying he went to court. He's been released. He paid a lawyer for that. Now, again, I'm not going to ignore the fact that jurors might find this distasteful.
And remember, as well, it's relevant to also to show, or potentially in count 1.
So YSL has a history of being released on crimes that the state doesn't have any evidence of them committing.
The state's going to make the argument whether or not a jury will buy that particular argument is totally up to them. And remember, they sift and weight the evidence. I give them the law that they'll apply the evidence as they determine it to be, and then they render a decision. And so we'll have to kind of wait on that.
Your Honor, I appreciate that, but you are a very important person in this process too. And I know I don't need to remind you of that. And I give you the utmost deference in that respect. you are the one that has to determine what the jury hears and doesn't hear. And putting a lyric that I wholly admit, if Mr. Stillwell said, Max, I got to consult you before I rap about this, I'll say, hey man, that's a little distasteful.
But
You
then
might not like that.
But rapping about something that might be a statement against interest, an admission, a confession, or some other thing that might get you cross purposes with a prosecution for a crime that may or may not have occurred. Well, that's another thing.
Your Honor, I just beat a murder rap is in no way an admission. It's in no way a confession to any crime. That's my whole point.
But it might be a declaration against interest, and
It's not. It's no way
and
a
it might
declaration
be a
against
party
interest.
admission on behalf of your client.
Saying you went to court.
Okay, you said that 3 times now.
Okay.
Was there any other additional argument as to that?
Well, and then, Your Honor, the state also added that they wanted to bring in other things that my client allegedly said, and this goes back into what Mr. Weinstein was saying about his client and the timing. They say they want to use "I keep a stick, ain't no avoiding no smoke" on that slime that they always talk about. And they said, well, the stick that's relevant, he's in this video with Mr. Comarvius Nichols, and in 2022, he's accused of committing a murder of Mr. Shmal Drinks with Mr. Nichols as well as Mr. Farley and Mr. Garlington. This as an admission has the same problem that Mr. Weinstein was talking about with Mr. Kendrick. This was recorded in 2009. My client is constrained by laws and time like the rest of us. He cannot confess in 2019 for an alleged crime that was committed in 2022. That is an impossibility. To say that his mens rea is the same for 3 consecutive years is to truly treat the aspiring rapper SB.
So when did he make this song?
The state in their recitation of facts said 2019. I take it meant to word.
Okay.
And I don't believe that is false.
When did this particular incident occur?
March 14th of 2022.
Okay, all right.
So that would be. So
that was the homicide, the reported homicide of
Shmal Drinks.
Shmal Drinks.
So again, to say that it's clearly not an admission. So, and to say it's his mens rea that's just static for 3 years because he's a rapper, I find is singling out. I'm very hesitant to just make these broad proclamations that rap music is singled out. But if we are treating rappers who are actually performing under stage names, if we're pretending that they are different than the rest of us humans and they have the same mens rea for 3 years and it never changes, we can always hold them to that, to things that we thought they were thinking several years before, and apply that to a crime 3 years later, I think we are treating them differently. And for those reasons, Your Honor, I believe that those are the only lyrics that directly affect my client. I do believe that, the state, I would yield to Mr. Steele to ably argue on behalf of his client, but I would ask that you rule that those lyrics I discussed as performed by SB in 2019 as inadmissible. Thank you, Your Honor. Sir. Mr. Steele?
evening, everybody. Your Honor, I just got today, just like I'm assuming everybody, the case law that is cited in the, I don't know what exhibit it is, but the PowerPoint. That's States 18, sir. Thank you. And I went through it as I sat here. And I'd like to just point out some observations. And I disagree with the way the state gives you, and you liked it, the linear ability to look at the law, because what the state does is ignores the First Amendment totally. Well, they say it's not a time. I'm looking at States 19. So if you want to take 19 and disagree with it, show me how I should consider it. I'll be more than happy to listen to it. I will. So, well, as admitted, we'll use as a party opponent by, I believe, Mr. Floyd and definitely Miss Hilton, I believe. And if I confuse them, I apologize. But I believe both of them. You have to analyze it under the First Amendment to the United States Constitution and the corresponding section. Do I have Georgia Constitution? Does it depend upon what is stated or what the material or is? Yeah, we have to go specifically lyric by lyric or video by video. And the reason for that is, as you heard, either or both Mr. Floyd or Madam Prosecutor Hilton, they were saying these are true threats. They were saying this is YSL. This is not a quote. I'm not quoting, but it's something effective. This is YSL warning others that don't bother us, these are my words, or we will retaliate. Those are true threats. And when you look at words with true threats, you have to ensure that they do not fall under the rubric of protected speech. So we have to analyze it. What the state though gave you in States 18, what I went through on page 14 of States 18, they cited Counterman versus Colorado. It's 143 Supreme Court 2106 2023. I will discuss that case at length. You sure it's on page 14? Yes. What case are you trying to refer to? I'm looking at what I believe you told me is States 18 on page 14 of what I got, and it says it has a 14 in the bottom left. Is it bottom left or right? Because it depends on. Okay, then bottom right is 7. All right, sir. Thank you. I apologize. I see what you said. So I'll talk about Counterman with the court's permission later today. But the state cites Harrell, Harrell versus State. It's 297 Georgia, 884 2015 case. They're talking Division 1 of that case, and they don't cite it for what it should be. Division 1 challenged Mr. Harrell challenged OCGA section 16-10-97A, as in Elisa and Alpha 1, as unconstitutional because it violates the right to free speech under the First Amendment. And our Supreme Court wrote, and I quote, in cases raising First Amendment issues, and then there's a ... an appellate court has an obligation to make an independent examination of the whole record in order to make sure that the judgment does not constitute a formal intrusion on the field of free expression. And that's what you need to do. That's what I'm going to go through. On page 8 of the state's handout, on States 18, on the top part, they cited the case United States versus Carpenter, and they cite that twice, the name Carpenter. But this is the 2022 U.S. Appeal Lexus 31605, Second Circuit 2022. And in that case, the court wrote, the Second Circuit wrote, the First Amendment does not bar the admission of rap lyrics where, as here, the artistic expression, and I quote, is not itself the prescribed conduct, ... And this is not a quote, this is my words, the rap video and lyrics speak to, with specificity, to the precise conduct in which he was charged, not general charges, but must be specific. So we need to go specifics. What the state is doing is saying generally, and they use the term mens rea and actus reus as if it's just obvious. But mens rea and actus reus come from OCGA section 16-1-4. And what that means is every crime charge has to have the mental state, the intent, or criminal negligence in some cases, not this case. And the actus reus is the act. And what the state is doing, though, is they are using it to show propensity. That is barred by OCGA section 24-4-404A. It is just bad character evidence. On page...
I don't think they used that to show. They didn't tell me propensity or anything like that. That would be a violation, but I don't see how this particular circumstance is propensity.
You need the specific at the time. What are we targeting? What they're targeting is these people have bad character. That's what they're saying. They're not getting
No,
to.
they're not. They're not saying. They're not introducing it for character. They're introducing it for statements against interest or admissions of a party opponent, if they're wrong, or adoptive admissions or co-conspirator admissions.
For what? For what crime? Think about it. What crime?
Well, that's for the jury to decide whether or not what they're introducing for a number of reasons. They're introducing not for crimes necessarily, Mr. Steele. They're introducing them to show different things like affiliation, gang, communication, and other things that they have that they think are relevant for purposes of to prove their case. They don't necessarily have to show it's a crime.
Okay. Affiliation under Rodriguez versus State. The leading case on gangs. Mr. Floyd was part of that case. I could be affiliated with a known. Okay. Mr. Carlson was involved in that case as well. Affiliation with a gang is not a problem. That is our right. I can be a member of the known criminal street gang. What I can't do, I could be proud member. I can say everybody should join my criminal street gang. We hate Jews, and that's what we do. And we associate with 3 or more people, and we're associating in fact. And our mission is to evaporate every Jewish thinking person in the world. And what we do then, we can march, we can protest, we can advertise, we can say that as many times as we want, unless it's a true threat, and I'm going to get to that. Unless somebody does a targeted, enumerated, statutory recognized criminal gang activity. That's the difference. And what we have here is using up Mr. Williams, prolific, accomplished songwriter, and they pull out lines to say it's his character. He is part of YSL. Being part of YSL is not the problem. That's why you need to look at it. That's the protected speech. What the state does not do is what the case of United States versus Carpenter that I just cited, and it makes you do, is we have to get into the specifics. It's not general. They're all general. On page 8 also, United States versus West, which is 209 U.S. District, Lexus 1830-07, Eastern District of Pennsylvania, 2019. That's not even a First Amendment case. The court discussed in that case that lyrics predicated on criminal behavior that was about to occur is admissible, not proof of past events. If the past events could be just reported, and that's in Division 3B is in Barry or Bravo 1. On page 9 of the state's handout of state's 18. United States versus Carpenter. Now it's a different Carpenter. 372F sub 3rd 74, the Eastern District of New York, 2019. It's been cited by the state in this state's 18 several times. And what Mr. Carlson said was, if Johnny Cash committed the crime in Reno, then those lyrics would be used against him. And that comes from that case. But that case also goes further, and it says it cannot be general. These lyrics cannot be general. They have to be specific in order to be admissible. And if you go then to page 15 of States 18, on the top part of the page, there's the same United States versus Carpenter. And in Division C, as in Charlie, thank you, I was going to say collect. Artistic, what the court wrote, and I should be quoting, artistic work that refers to a specific act or motive that can be tied back to the alleged crime can be highly probative. On the other hand, if Johnny Cash was charged with a crime not specific to his lyric, the prejudicial impact of using Cash's discussion of unrelated fictional crime is great prejudice and not probative value. That's why we have what the state is saying. They're giving you, like, you can use the word cookie. They're giving you like the crumb. They're not giving you the whole cookie. Is what they're telling you on page. Going back to page 9, on the bottom of States Exhibit 18, they cite United States versus Heron, HERRON, 2014 U.S. District, Lexus 63872, Eastern District of New York. In Division B, as in Bravo or Barry, the court wrote, I quote, "We are required in First Amendment cases to carefully review the record, and the reach of our opinion here is limited to the particular facts before us." And they cite Snyder, SNYDER versus Phelps, PHELPS, 315 Supreme Court, 1207 at 12/20/2011. But, Your Honor, in footnote 1 of United States versus Heron, what the state didn't tell you is that Heron conceded that the use of the videos as evidence was admissible for a relationship, to prove a relationship between him and the other individuals, and it was used for a proper purpose. It wasn't even argued. You have no concession here. In footnote 2 of that same case, which the state didn't tell you, and I quote, the court wrote, it's a district court, it should be noted that for the government to intimate during trial that defendant's speech itself constitutes criminal conduct would implicate the First Amendment. And that's what they're doing here. They're telling you we're not using the speech. They are using the speech. They are using speech for propensity. They are using. Keep saying that, but I disagree with you, Mr. How do you feel? I mean, because our appellate courts allow this particular type of association, not just barefaced lyrics or other things about gang activity, but if they go to a proper purpose, then certainly. But I disagree with propensity. They're not trying to do that. Well, I know that is the reason in my estimation, but you're the honorable court, so you may. I mean, we're gonna have to academically disagree. Oh, I understand. Okay. On States 18, page 10. That's again United States versus Carpenter. I discussed it. It's on page 15 as well, and I told you what the case really says. On page 10. On States 15, that's United States versus Cannon, CANNON, 753F 3rd 492 5th Circuit 2000. That's your third attorney, y'all. Under the First Amendment, that case is the insufficiency of the evidence case. Mr. Steele, I have Westlaw. I can look up all this, and I've been these cases. So if you want to just bring it, I mean, if you want to distinguish something, just tell me what it is. I'll consider it for the reason that you tell me. Okay. But I've got Westlaw right now.
All right, on page 12, you'll see States 18 Ward versus 339 Georgia Appeal 621 2016. That's not a First Amendment case. On the bottom of page 12, 402 24-4-402 specifically says, except as limited, all relevant evidence shall be admissible, except as limited by constitutional requirement, which is what we're doing here. We are challenging this evidence under the First Amendment. On page 14, the state cites United States versus Smith, 967 F. 3rd 1196 11 Circuit 2020. That's not a First Amendment analysis. They quote it, but it does not address the First Amendment analysis. And if you go to page 18 of States number 18, you will see on the top United States versus Smith. The First Amendment challenge was a First Amendment challenge to admissibility of a rap lyric, but they found it admissible because Smith used the same or similar gun in the video that was identified by the victim of the armed robbery and wearing the same exact sweatshirt as was committed during the armed robbery. We don't have that here. You have true words. You don't have anybody that I heard saying anything about, here is the gun. They're using terms that we will show you, with your course of permission. They're commonplace. Your Honor, page 17, Carson, C-A-R-S-T-O-N versus State 310, Georgia, 797-2021. It's not a First Amendment case. And that's what we're challenging under it first. That's our first line. Page 18 of States 18, Taylor versus State, Taylor 297, Georgia, 132, 2015. That is not a First Amendment case. Shattuck, C-H-A-D-D-O-C-K, versus State, 203, Southwest 3D, 916, Texas Appellate Court, 2006. That is not a First Amendment case. So these cases are just not applicable. And the last ones are on page 21 of States 18. People versus Zepeda, Z-E-P-E-D-A 167, California Appeal 4th, 25, 2008. And on the bottom of the page, State versus Burmeister, B-U-R-M-E-I-S. TER 131, North Carolina Appeal 1998. Neither one was a First Amendment case that was reviewed. The first one, People versus Zapata, that was tried to be reviewed on First Amendment grounds in appeal. It was not preserved at trial, so the appellate court never even reviewed it. The natural born killer case that was announced by the state, Beasley, B-E-A-S-L-E-Y versus State 269, Georgia, 1998. Page 22, that's not a First Amendment case either. So, neither is on page 23, 424, Jackson versus State, as well as Fleming versus State. Neither one are First Amendment cases. Mr. Carlson also cited United States versus Hankton, H-A-N-K-T-O-N. It's 51 F 4th, 578, 5th Circuit, 2022. That's a case where a rap video was used. It's in Division 3. What it did not tell you was what the court said when you keep asking about these are admissions, these are confessions, these are adopted admissions. What you're being
All right, y'all. I'm a little tired, so I'm gonna stop right here, okay?
It was just decided.
I'm so tired.
Find out.
So we'll call it a quit right here. Okay. Thanks for joining, and your reaction is very important to me to the case. I like for people to speak their opinion